In continuation of the principles covered in previous modules on land use, vacant land, and development, this section explores the specialized and complex field of commercial real estate acquisition in Arizona. Commercial real estate differs fundamentally from residential or vacant land transactions because of the magnitude of financial investment, the complexity of property use, and the legal implications associated with ownership. Among the most critical of these responsibilities is due diligence, the systematic process of investigating a property's condition, legal status, and potential liabilities before completing a purchase. In Arizona, due diligence in commercial property acquisition is not just a matter of professional best practice. It is a legal and ethical obligation for real estate professionals under AAC R4 28-1101A, which requires licensees to protect the public by exercising reasonable care and competence in all transactions. The failure to perform adequate due diligence can expose both buyers and brokers to significant financial losses and legal liability. The due diligence process ensures that buyers have a complete understanding of what they are purchasing, including environmental, zoning, title, and operational risks. One of the most critical aspects of due diligence in commercial transactions involves environmental liability, governed primarily by the Arizona Department of Environmental Quality, ADEQ, and the Federal Environmental Protection Agency, EPA, under the Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA. Often referred to as the Superfund Law, CERCLA imposes strict liability on property owners for contamination found on their land, even if they did not cause it. In Arizona, this responsibility is mirrored by the state-level Water Quality Assurance Revolving Fund, WQRF, program under ARS. Paragraph 49-282, which authorizes ADI to remediate contaminated sites and seek reimbursement from responsible parties. For example, a developer purchasing an old industrial warehouse in Tempe might later discover that the soil and groundwater are contaminated with hazardous chemicals from a prior tenant. Under CERCLA and WQRF, the new owner could be held liable for cleanup costs, even if they were unaware of the contamination at the time of purchase. To prevent such scenarios, buyers typically commission a Phase 1 Environmental Site Assessment, ESA, which investigates the property's history, prior use, and any potential environmental risks. If red flags are found, a Phase 2 ESA may follow, involving physical sampling of soil, water, or building materials. The importance of these assessments was underscored in the landmark case United States versus Best Foods, 1998, where the U.S. Supreme Court held that parent corporations can be held liable for environmental contamination caused by their subsidiaries if they exercise control over the operations that led to pollution. This case reinforced the need for corporate buyers to perform thorough environmental due diligence and structure acquisitions to limit liability exposure. In addition to environmental concerns, Arizona commercial buyers must be mindful of AZDA, Arizona Department of Agriculture, liabilities, especially in properties with prior agricultural use. Under ARS, paragraph 343, the AZDA regulates pesticide storage, hazardous material handling, and soil contamination from farming operations. Commercial developers acquiring former farmland must verify compliance with these regulations and determine whether any cleanup or soil remediation is required before redevelopment. Due diligence also extends beyond environmental and agricultural concerns. It encompasses zoning compliance, title verification, lease review, and financial feasibility. Arizona municipalities, through zoning ordinances and general plans authorized by ARS, 309-462.01, control land use and permissible commercial activities. A buyer must confirm that their intended use, such as converting a warehouse into retail space, conforms to local zoning codes and development regulations. The broker's duty under R4 28-1101K requires them to recommend professional assistance when a client's transaction involves complex legal, technical, or environmental issues beyond the broker's expertise. A well-executed due diligence process may also uncover ADA, Americans with Disabilities Act, compliance issues, which are especially relevant to commercial properties with public access. Under the ADA Title III, property owners are responsible for ensuring that buildings are accessible to individuals with disabilities, including ramps, door widths, restroom facilities, and parking areas. Failure to meet ADA standards can result in lawsuits, fines, or forced retrofitting. For example, a property manager who purchases a strip mall without verifying ADA compliance may later face tens of thousands of dollars in required accessibility improvements. Katina v. Raytheon Co., Appellate Division of the Superior Court of New Jersey, 2016. Buyer discovered extensive environmental contamination post-closing that had not been disclosed, and the court applied the discovery rule to allow fraud claims against the seller even many years after the sale. In this case, a purchaser of commercial property later discovered significant environmental contamination that had been only partially remediated before closing. The prior owner and lender had arranged a cleanup and provided affidavits stating the property did not require further cleanup, but failed to disclose ongoing contamination or the partial remediation to the buyer at closing. Years later, when the buyer's environmental assessment revealed a longer and more extensive history of contamination, the buyer sued the seller for fraud and non-disclosure of environmental conditions. The court applied the discovery rule, meaning the statute of limitations didn't begin until the buyer discovered, or reasonably should have discovered, the underlying facts, and allowed the fraud claim to proceed even though more than a decade had passed since closing. Ultimately, the principle of buyer beware, caveat emptor, remains highly relevant in commercial real estate. While consumer protection statutes safeguard residential buyers, commercial investors are presumed to be sophisticated parties with access to legal and technical counsel. Nevertheless, the licensee's ethical and statutory duties require guiding clients through the due diligence process to minimize risk. Review summary: Due diligence in Arizona. Commercial real estate protects buyers and licensees from legal and financial exposure. It includes comprehensive investigations into environmental contamination, agricultural history, zoning compliance, ADA accessibility, and title integrity. Environmental assessments, such as Phase 1 and Phase 2 ESAs, are vital tools for identifying potential liabilities under federal CERCLA and state WQRF statutes. Brokers must act with reasonable care, recommend expert assistance, and ensure full disclosure of known issues. Through proper due diligence, buyers avoid costly surprises and ensure that the property's condition and legal status align with their intended use. Discussion prompts. Why is environmental due diligence especially important in Arizona commercial real estate transactions? Answer: because under CERCLA and WQRF laws, current property owners can be held financially liable for contamination, even if they did not cause it. What are the primary environmental assessments used in due diligence? Answer: Phase 1. Environmental site assessments identify potential risks, and Phase 2 assessments involve physical testing for contamination. What does AAC R4 28-1101 require of real estate licensees regarding due diligence? Answer: it requires licensees to exercise reasonable care and competence, and to recommend professional assistance when specialized knowledge is needed. Closing remarks. Due diligence is the foundation of professional competence in commercial real estate. Arizona's legal framework expects brokers and buyers to conduct transactions with informed awareness and precision. Environmental, agricultural, and ADA liabilities can transform a profitable deal into a costly disaster if ignored. A knowledgeable and diligent real estate professional not only fulfills their statutory and ethical obligations, but also protects clients, promotes trust, and enhances the integrity of Arizona's commercial real estate industry. Supporting sources and key case law ARS. Paragraph 49, 282. Water Quality Assurance Revolving Fund, WQARF, CERCLA, 42 USC, paragraph 9601 ASCQ. Comprehensive Environmental Response, Compensation and Liability Act ARS, paragraph 3, 3 and 43. Arizona Department of Agriculture Soil and Pesticide Regulation, ARS, paragraph 9462-01. Municipal Zoning Authority, AAC, R428, R1101. Standards of Professional Conduct and Disclosure Obligations for Licensees. United States versus Best Foods. 524 U.S. 51, 1998. Parent Company Environmental Liability. Katina v. Raytheon Co. Buyer's duty to conduct environmental inspection.